And now we have, and I apologize, James Kreitler, followed by Kristen Seymour. Sir, I apologize. Did I pronounce
You had it absolutely correct.
Oh, thank you.
I'd like to thank the task force for your work, and also thank my state representative, Tony Huang, who's supported me over the last week or so to appear before you this afternoon. My name is James Kreitler. I live in Fairfield, Connecticut, and I'm here very simply to speak in favor as a father for shared parenting. I'm not going to go through my entire testimony, but I do recognize these issues are highly emotional. I recognize that divorce is very difficult with a lot of anger on both sides. My purpose here is not to substitute emotion for what I hope to be a reasoned analysis and response by the task force. I'm here to represent myself and my kids in the hopes that something may change in the future and that other parents may not find themselves in the situations that I'm in and that so many others behind me find themselves in today. My conflict started in late September 2012, having been divorced as of September 2010, when I started to make inquiries to my ex-wife about her situation in possible violation of the divorce agreement around cohabitation and certain financial matters. Irrespective of any of the merits of her position or mine in this conflict, there is no way that any of this should have been shared with our children, then ranging in age from 18 to 11. In fact, she did do just that, specifically telling the kids that I was trying to ruin her, that I was suing her. And this is from a person who had recently purchased a very expensive home and had also simultaneously owned a home of equal value, if not more, that I had deeded over to her, and this is for someone who's a school teacher by trade. So I believe I had rights to at least make inquiries as to her situation post-divorce, and what I received in return was her using the kids to alienate me from them. I live 1 mile away from her and the kids. I went from seeing my kids about 35% of the time, which is what the divorce agreement stipulated, to not seeing my then 14-year-old daughter for 6.5 months and not seeing my then 16-year-old son for 4 or 5 months. I see them very sporadically. I had an episode that I don't have time within the 3 minutes to describe regarding the attempt to work with a parenting coordinator. But suffice to say, I'm reduced to texting my kids, emailing, in essence begging to have dinner or otherwise spend short periods of time with them. The answer I get from my ex-wife is that the kids don't want to, which of course begs the question of why they don't want to see their dad, and she gives them free rein to spend time where they want, with whom they want. I've had significant issues with at least one of the kids because of the lack of supervision. She showers them with material things, and in exchange she gets their pity and their alliance to exclude me. The bottom line is that kids need both parents, period. I can tell you, as in terms of the divorce agreement, there are other aspects of the divorce agreement that are fully enforceable, and in fact, in terms of all the financial obligations, I give her 50% of everything I make dutifully every month. And in fact, if I were ever not to uphold my end of the bargain under the divorce agreement, you can be darn sure that I would be dragged into court in a New York minute to suffer the consequences, when in fact it appears that the courts are unwilling to hand out any penalties to her for what is substantive alienation of the kids. I've tried to go to court. I spent $60,000 and got absolutely nowhere. She used the court system to run out the clock and create facts on the ground in terms of encouraging and allowing alienation to occur. So by the time that my 50-50 parenting motion saw the light of day, as a practical matter, it was moot, because the kids had already been convinced that they didn't want to be with me. So in closing, my hope is that 50-50 default shared parenting will be the norm. As I mentioned, I only got 35% at the outset, rather than spend even more time and trauma for the kids to fight for more. But nonetheless, for others that may come in the future, I also am not opposed at all in the attempt to enforce good parenting practices, which, let's remember, it's ultimately about the kids. I am not at all opposed, and in fact am in favor of fines or even some small jail time in order to clear the mind of those that would engage in this type of daily alienation. I was very, very involved in my kids' lives. The message that's been communicated to them is that I am optional and they need not deal with me if they don't wish, and they follow behavior modeled by their mother, which is complete indifference as to my role in their lives. Thank you.
Sir, has the court heard and ignored the evidence that she is not facilitating the court-ordered parenting plan? I mean, you have a court-ordered plan, and she's obviously not, according to you.
If I can describe to you my struggles to implement a parenting coordinator into our process, and it started with my now 17-year-old son in April 2012. So this is approximately 3 or 4 months after I had initiated informal inquiries with her as to what was happening, given that the fact that she owned 2 homes totaling $1.7 million on a $47,000 a year salary, had a boyfriend who lived there 5 to 6 nights a week. I know that he had a fairly lucrative job, so it made sense to me that I had a right to inquire. So approximately 4 months after I started those inquiries, both informal and formal, our son had a depressive episode, which resulted in him entering certain treatment. It was agreed by both my ex-wife and I that he would then enter a therapeutic school in another state in New England. I'm sorry, let me correct the record for a second. I apologize. His entrance into the therapeutic school was in August of 2012. My inquiries started in November of 2012, and that's an important fact that I want to correct. Because in late December 2012, while he had just gotten back from a school vacation back to his school in New England, she drove up there and pulled him out without my knowledge or consent, in direct violation of the joint legal status that we have in the divorce agreement. My point is, I filed a contempt motion. That took, of course, 3 or 4 months to hear in court. We never got there because in the meantime, our son had been placed at the local high school, and the idea that I was going to forcibly take him out mid-semester and go back to this school, which, by the way, would not have him back once they are informed that the parents are in conflict. So in exchange for the contempt motion, I said, I will drop the motion if we hire a parenting coordinator to get this situation fixed. I did not pursue sanctions by the court because it wasn't right for my son, and I wanted to try to fix whatever this problem was that we were having. We hired a parenting coordinator as of July 2013. My ex-wife participated for about 4 weeks. The requirements were things like writing emails back and forth. This is all about increasing communication between the parents so that we could talk to the kids. Hey, how was your weekend last weekend? How was your sleepover? And try to engage on a level that involved everyone in the family, even though it's a divorced family. My ex-wife participated for all of 4 weeks, promptly blew the whole thing off with no penalty whatsoever, unless, of course, I wanted to spend more time and money and months upon months trying to get her sanctioned through a contempt motion. So what's happened then is basically nothing, because I've had the parenting coordinator be, as far as I'm concerned, ineffectual in communicating to my ex-wife the necessity and the imperative nature of participating in this process. Instead, it's been a very hands-off process where, we don't want to alienate anyone from the process itself. So, I'm very hesitant to basically tell my ex-wife the blunt truth, which is she needs to be a participant in the kid's interest. So in essence, she blew off that parenting coordinator. I don't really feel like paying the coordinator anymore, and I'm not going to engage as the only parent in the process. So that process has been suspended. A couple of the kids do see therapists, sometimes separately, sometimes with me, sometimes together. There is no overarching plan. There is no communication. So that's my 17-year-old son. My 15-year-old daughter, I didn't see her from January 24, 2013, when she walked out of my house on a winter's night and was promptly picked up by my ex-wife's boyfriend, which to me is an outrage that he would insert himself into a conflict like that. And I didn't see her again until August 18, 2013. I've seen her perhaps 4 times since then for very short periods of time, an hour for dinner, something like that. They have full optionality as to whether or not they ever see me. My ex-wife claims that she encourages them to see me. I see zero evidence of that. And my question to the task force is, what can we do to introduce some enforceability into what, in my view, are common sense, good parenting practices? And my view is, right now, all of us are stuck with a very expensive, very long process which renders whatever motion you're trying to get heard impractical or moot because the other spouse is allowed to create facts on the ground. So that's why I'm not opposed to fines or even a little bit of jail time to clear the mind.
Thank you. And Representative Vargas has a question. And then Dr. Thayer.
Do you have any specific recommendations in terms of the legal system and what's lacking there and what could be done to improve it?
My view is there needs to be some sort of fast track. And I never hired a GAL, first of all, because I'm a financial advisor by profession. I have a very high fiduciary standard that I have to meet for my clients. Everything I heard about GALs was that it really wasn't that difficult to become a GAL. There's total immunity, which scared the you-know-what out of me. And frankly, it wasn't really difficult to do that. And so I ran away from the GAL before it even became a serious consideration. But my view is there needs to be some sort of fast track to make sure that ongoing parenting is abiding by the provisions of the divorce agreement. We do have a written stipulation that matters that are strictly between mom and dad will not be discussed with the kids. For me to enforce that would cost me X thousands and X number of months, and as I say, it doesn't. There's no solution there. So my view is, I'm not a lawyer, but there needs to be some sort of fast track or perhaps mandatory therapy. My macro view is that putting the emotions and the children's lives in the format of an adversarial court system or judicial process is a complete fallacy. It serves those in the system who make a living off of it, but it doesn't serve the kids. What I would love to see is mandatory therapy with sanctions if you don't participate. I would love to go to therapy with my ex-wife to work on how we figure this out. But she has no sanction, no incentive, no nothing to participate in a process like that. So all I'm asking for is some fast-track way to enforce divorce agreement provisions. The financial part is very quickly, swiftly, and severely enforced, should, in my case, I not abide by it. Her responsibilities, which are just as important in terms of encouraging parenting from both parents, she has no sanction, no penalty if she chooses not to abide by it.
I appreciate that answer. Thank you, Dr. Thayer.
Thank you for coming, and I want to agree with a lot of what you said. As someone who is a parent counselor, our frustration too is when there is not a court order in a case like yours. In many cases, people voluntarily come and we can go forward. But you're absolutely right. I have, and this may upset some people out there, had some very wonderful GALs who've been a real advocate of that, so that if people did not come, I had a JL to turn to, who would then take it to court for me. So, and I would notify everyone immediately when people didn't come. So many times in people's divorce orders, or just by appearing in court, they are ordered to come. I prefer an order where there is an open end to it, where it isn't like 3 sessions or something
Correct.
like that, that, you know, what can we do? Or people wait that out. So I know I haven't asked a question yet, but I think that's what you're saying, that orders for participation in parent counseling, however we want to phrase it, because we don't really, parent coordination in this state is still by mutual agreement between parents. We don't have an order for that, but order for parent counseling, especially early on, with some ability to return it to court, which is always my frustration if people don't participate, would have been helpful in your case.
Yeah, and I think, and my view, just following on that, is that the stipulation that there be mandatory therapy or other family counseling, there needs to be a very high bar for someone not to appear for those sessions. In other words, you know, we've all suffered from continuances for months and months and months while kids' lives are at stake here. You know, it seems to me that the simple ability to fax in a continuance to a courthouse, it doesn't cut it. You know, we're trying to, time is of the essence in these matters, and there seems to be a complete lack of recognition by the system that you know, literally every day things can happen which can either benefit or hurt kids in terms of their ability or willingness to interact with both parents. So my point to you is, as a follow-on, is that there needs to be a very high bar set for people to opt out of this, and they need to, you know, to me, there's no reason why they couldn't be summoned to court within 3 days and made to explain why they missed a session, period.
I agree.
End of story.
I agree with you. I mean, we sit there many days on snow days and other days with a lot of excuses for sessions,
instead,
and I agree with you.
The continuances and the delay and the obstruction are of the same manner as all of the other issues in the divorce, including financial issues. And we've all suffered from, you know, the slow drip of financial disclosure, for example, you know, while people try to do other things with their money. In my case, you know, I tried to go in and modify my alimony based on what I see as very substantial evidence of outside support. And I got nowhere because of the ability to obstruct. In my view, for parents to obstruct or delay attending family counseling is even more egregious. And it's an outrage, and it leaves the kids, as we all have heard today, it leaves them bereft of really important time. I have kids that are teenagers. I have a 19-year-old in college. The rest are in incredibly formative years. And they don't have me as an ongoing presence in their life, other than on text.
I think
Thank you.
that your comments about the delays and continuances are something we've heard from a lot of people, something we've heard throughout our entire length of our formation, and I think it's something that is, we've all said, I think we have a consensus that it is a problem. We do consider it a problem, and we are looking at solutions for those delays. It is, I think, unconscionable that people have to wait as long as some of the stories we hear to get before a judge when someone is denying them the court-ordered access to their children. It is unconscionable. And we have, did you have a question? Yeah, Representative Vargas.
One more quick question. You've highlighted some of the things that are lacking in the legal system, among them the lack of a fast track, the lack of any teeth in terms of enforcement of court orders. Are there any other things you think are lacking in the legal system, the way you've experienced it?
I'm just going to say, and I use the word asymmetrical in my testimony, in my written statement, because it is another more blunt way to say that. It's completely unbalanced in terms of the approach. The approach is designed to generate conflict. As I said earlier, this is an adversarial format where you're trying to reach, hopefully, a consensual result. To me, it's a complete contradiction. You know, that's why, and basically my last sentence in my statement says, you know, the more you get the lawyers out of it, the better off everyone's going to be. Which is why I think mandatory family counseling it should be first before any, you know, court motions are allowed to be entertained, period. You know, I did attend a mandatory class, a parenting class, during the divorce process. I won't give you my opinion of it other than to say it was perfunctory, it was check the box, it had very little value by nature because there's 50 people in the room. But that to me is completely inadequate relative to what should happen. In my view, if I had a clean sheet of paper, mandatory family counseling to understand what it is that each party wants, only followed by court action. Because when you start with court action, by definition, you're starting with conflict. It amps everything up. The chances of having, you know, a fairly amenable, consensual result are close to zero.
So basically, you're saying there's not enough in terms of getting people off into conciliation. Immediately,
At all.
they're
What would it hurt to have a mandatory, however you want to describe it, mediation, family counseling, perhaps individualized therapy? I understand that there's a huge money issue here, but the fact of the matter is, to me, the chances of success for the kids to have both parents play a substantive role in their lives under that scenario compared to what exists now, that's a slam dunk.
Dr. Horowitz and then Mr. Weisman.
As a therapist myself, it's unfortunately true that there are good and not so good people in my profession, just as there are in the legal profession. And I'm wondering if you have any thoughts about really what kind of therapy would be helpful and what kind of therapy wouldn't be, and how to put some teeth into the therapy so that it isn't just sitting around, accomplishing nothing. Because unfortunately, a lot of therapy in higher conflict cases doesn't really change anything. And it's not a secret. There's a lot of literature about this phenomenon. And if I may just say one more thing before we have a chance to answer. You trying to understand what number of things went wrong in your very sad story. I'm struck by the fact that you had mentioned hiring a parenting coordinator, and I assume that was by agreement with your ex.
Yes.
Was there a contract defining the role of the parenting coordinator or how that whole process is going to work? Because as much as I agree with you that it's best to keep this out of court, it sometimes is really important to have something that looks like a contract that just makes it very clear what's expected, and in fact, even to give some measure of decision-making authority for minor things to the so-called counselor. And that's really how a parenting coordinator differs from counseling or therapy, that there's some decision-making authority vested in that professional. And I don't know if any of that was in your agreement.
The major, in my experience, and I've been to therapy a fair amount. My kids, particularly 2 out of the 4, have been. I've been involved in therapy, whether it's family or in the early stages of my divorce process with my ex-wife, so I feel like I've seen it from many angles as a participant. The major difference, and the thing that got me, for lack of a better term, excited about the prospect of having a parenting coordinator in the process, was that she had the right to testify in court, because it was very apparent to me that my ex-wife was opting out of everything, not only the encouraging of having a father in the kids' lives, but also she was opting out of court orders. And so I was hopeful that when the parenting coordinator was signed off by both of us, and let's remember, it was only because I agreed to drop a contempt motion. This was not some revelation my ex-wife had, as far as I'm concerned. She also incidentally agreed to pay a disproportionately high amount of the initial retainer as part of the agreement to hire the parenting coordinator, which is as close as I got to an admission on her part that perhaps she shouldn't have unilaterally pulled our son out of a therapeutic school or any other school for that matter. So the major difference in my mind is that the parenting coordinator had the right to testify and report back to court as to her findings. I thought that that was going to be a powerful enough lever to pull if I felt from my side that I needed to do that, and it also was going to keep me honest. Let's be honest. Let's be fair. So it was something that could be used by either side to bring to light in court their position in this parenting conflict. So I don't have a great answer as to what type of therapy. I can tell you I've used all manner. I've used, group. I've used one-on-one bilateral with 2 out of the 4 kids. To me, it's. I totally agree, and if you like, you can throw my profession into there's great people in it and there are some not so great people in it. I'm not sure I have a great answer for you other than, in my experience, I was hopeful the parenting coordinator would come in and frankly instill some discipline on both sides into the parenting process in the interest of getting some consistency around the kids. And it didn't appear to faze or intimidate my ex-wife because she fairly quickly dropped out of the process. And in essence challenged me to yet again go back to court. And as yet I've not been willing to do that because for a lot of reasons.
Thank you. I think, Tom, you were next. Okay. So thank you very much, sir. I appreciate it. And we have your written testimony to refer to also. Thank you. Next we have Kristen